Okay, this is the discussion over the judicial branch. Now, the only court that was set up in the Constitution was the Supreme Court. Then Congress would make all the other courts it wants to. And almost even today, almost all of the courts was set up in 1789. Now, we have three basic divisions of federal courts. We have the district courts, which almost 90% of all the cases start there. Now, they have original jurisdictions. That means how does the court get there? Original, well, it can start there. And it is still the only federal court that actually has a trial. Now, the Court of Appeals was designed to take some of the load off of the Supreme Court. And it only has appellate jurisdictions, means there is no case that can start at the Court of Appeals. And they can only hear cases from lower courts. And 90% of the cases, of course, as you would imagine, come from the district courts. Now, the Supreme Court is the highest court in the land, 9 members, set by Congress. Their salary is set by Congress. And they can pretty much decide what court case they want to hear. Now, the problem is there are over 7,000 cases that are sent to the Supreme Court, and they can only hear about 200. So obviously there's going to be a lot of picking and choosing. Any interested party can send a brief, that's a kind of a summary of their opinion on a court case. So if you have an opinion on where a court case should go, you could actually send something to the Supreme Court. Not sure they would read it. Now, probably the most well-known court is the Warren Court, even though he was appointed by Eisenhower, which was conservative. He became one of the most liberal judges we've had. Now, most of the cases, the judges do not like to overturn themselves. So they do not want to overturn decisions that was made in the past, although they do sometimes. Now, so how are we going to decide which of these 7,000 cases we're going to hear? So the judges, divide up the cases, and they all talk about them. And then if 4 of the judges want to hear a case, then they hear a case. And that is called the rule of 4, obviously. Now, so what happens to the rest of them? All those other cases they're not going to hear. Well, it is called let the decision stand, meaning if they do not want to hear it, or if there's a tie vote, the last decision stands. So if the Court of Appeals said you do not get a new trial, and the Supreme Court decides not to hear your case, well, then you will not get a new trial, because that was the last decision. Now, excuse me. Now, there are basically 2 types of judges and how they look at the Constitution. Strict interpretation means that they try to determine what would the founders think about this case, and then vote that way. Now, the other one is a liberal interpretation, which means they believe the Constitution has multiple meanings and kind of a living, breathing thing, so they can pretty much decide the way they want to on it. Now, as we all know, judicial review gave the Supreme Court the right to declare laws unconstitutional, and that was in the Madison case. Of course, that would go for a lot of things. Now, all right, very quickly we're going through court cases. I know you can read, but I may add a little thing to it. Okay, the Greenwood case. You need to know the term expectation of privacy. It's used a lot. That means that an average person would not believe that person still wants his trash. Like if it's in the kitchen, no, police cannot search it. In the garage, no, but but on the sidewalk getting ready to pick up, yes, they can. Matt's case says if you find evidence illegally, even though it shows that a person is guilty, you still cannot use it in court. Maryland case set up implied powers, also called the elastic clause, and the phrase you may hear on your test is necessary and proper. So if you hear necessary and proper, they're talking about the Maryland case. Okay, of course, we all know the Board of Education, the Brown versus the Board of Education. It overturned the Plessy case, and they'll ask that a lot. Now, you need to remember clear and present danger talks about when can you stop someone's speech or movie or book and just stop them. It has to cause a clear and present danger to the government. Roe versus Wade just said that the states had limited abortion too much, and there's got to be some other ways. Please go back and rewrite your laws, and we're still rewriting them. Plessy case set up the famous separate but equal. You can separate the races if your facilities are equal. All right, Engel case, a state written prayer is illegal, and of course that would be included schools. Miranda, you have the right to remain silent. You have a lawyer if you don't have one. The New York case was the First Amendment to be incorporated. Incorporated is important because that means that an amendment to the Constitution is added to the states. And the reason it's important because the Baltimore decision right at the very first said the Bill of Rights did not apply to the states, so we had to incorporate each one of them down the road. All right, let's see. Okay, get a right to have a lawyer. The Beck case set up reverse discrimination, and it hurt affirmative action. The Nixon case, even the president is not above the law. And the Miller case gave us guidelines if you want to write obscenity laws, and it said that the obscene material does not have First Amendment protection. In the Lemons case, talked about how the government can assist religious schools. It's also called the Lemon test, so you may see the Lemon test on your test instead of the Lemon case. All right, thank you, and this is signing out.